7. Leases made pursuant to Land Transfer Form Act. In the event you see a lease with an introduction that states made pursuant to the Land Transfer Form Act, please note that certain terms are abbreviated and will have an expanded meaning as noted in that act. Please find attached as Appendix A to these materials a copy of the Act with the abbreviated terms and the expanded meanings. Most modern leases do not contain this reference, as the lease document itself will contain all of the terms and obligations. Test your knowledge. For in a gross lease, is the cost of utilities included in the rent? Yes, no, or maybe. 5. Which is better for a tenant, renewal or extension? 6. Under the covenant of quiet enjoyment, is the landlord liable for nuisance arising from the activities of other tenants in the building? Yes or no? 8. Leases of strata lots. Commercial strata lots are becoming very common given the number of mixed-use developments constructed in Metro Vancouver over the last few years. There is a difference between the leasing of a non-stratified fee simple property and a strata lot property. In the case of a fee simple ownership, the owner owns and controls all of the lands and buildings contained within the property. In the case of a strata lot or strata lots, the owner owns only those specific strata lots registered to it and may not own the entire project. Or if it does not own the entire project, does not control at least 75% of the votes in the strata corporation. In the case of a strata lot, the strata owner is a member of the strata corporation, and it is the strata corporation which owns all of the common property and which exercises control over it. It is not unusual to find a commercial strata lot leased on a standard form commercial lease. Such a lease is inappropriate and in some cases can lead to results which are not manageable. A simple example is that in a commercial lease, it is the usual covenant that the landlord be responsible to repair the building and to maintain insurance on the building. The landlord of a commercial strata lot cannot control the repair of the building, as it would form part of the common property which falls within the control of the strata corporation, and insurance on the building would be a strata corporation matter governed by the provisions of the Strata Property Act. Some of the significant differences between a commercial strata lot and a commercial non-strata property lease are A. Area of the premises. As we have previously discussed, the area of the premises in a commercial lease is often determined under BOMA standards, yet the area of a strata lot is defined pursuant to Section 68.1 of the Strata Property Act, and that section refers to the boundary shown on the filed strata plan. There may be an inconsistency between these two calculations, resulting in different area calculations. If the lease is of a whole strata lot, there will be no issue with respect to the payment of taxes and operating costs, as it will be 100%. The difference will arise if it is not a lease of the whole strata lot and the tenant is to pay its proportionate share. B. Common area costs special assessments. In a non-strata lot commercial lease, the norm is to allocate to the tenant its proportionate share based on area of the operating costs and taxes. These will be costs allocated to a building or project as a whole. In the case of a lease of a commercial strata lot, these costs will be applicable to the specific strata lots in which the premises are situated. These costs will include strata management fees charged by the strata corporation and any costs which the landlord may charge, such as janitorial costs, costs of insurance specific to the strata lot, management costs, and any costs which are specific to HVAC to the strata lot. While there is a potential to challenge the operating costs under a non-strata lot commercial lease, the tenant will not be able to challenge the landlord with respect to the operating costs charged as strata fees in the case of a commercial strata lot lease, as these are determined by the strata corporation, not the landlord. A tenant will want to exclude special assessments for capital purposes. C. Property taxes. Property taxes will be levied against each specific strata lot, and the tenant will pay its share based on the strata lots leased by it. D. Proportionate share. The norm for the determination of a tenant's proportionate share will be based on the area of the leased premises, calculated in accordance with the terms and conditions of the lease, and the area of the shopping center project. In the case of a commercial strata lot lease, it will be based on the area of the specific strata lot. The tenant will not be paying costs relative to the building as a whole. These costs are captured in the common area maintenance costs. E. Tenant improvements and repairs. In a commercial strata lot lease, it may be necessary for not only the landlord but the strata corporation to approve any work to be undertaken by the tenant. This is particularly so if such work is outside of the strata lot, such as, for example, the installation of an HVAC system or a sign. When acting for a landlord, it is also prudent to include in a commercial strata lot lease the right of the strata corporation to inspect. Going to page 33 now. F. Landlord covenant to repair. The landlord must ensure that the lease does not obligate it to repair the building in which the leased premises are situated, or to repair any building services or structural components. The landlord, in all likelihood, has no authority to do this, as those components will fall within the control of the strata corporation. To impose such an obligation on the landlord would be to obligate it to undertake a task for which it has no authority. G. Exclusive use. A tenant will often require of a landlord that the tenant has exclusive use for its specific business or service. In the case of a non-strata commercial project, the landlord has control over all commercial units. In a strata development, the landlord will only be able to control those strata lots which it owns. Therefore, the tenant is at risk if it expects to have an exclusive right. Other strata owners may lease to a tenant which carries on a competitive business. If the landlord has control of at least 75% of the votes, it can amend the bylaws of the strata corporation to impose restrictions on use and effectively give the tenant certain exclusive rights. If the landlord does not, the tenant is at the whim of the other owners. H. Parking. In the case of a commercial strata lot, parking will either be common property allocated by the strata corporation, limited common property, the use of which is restricted to those strata lots for which it is limited common property, or allocated by way of a lease for a specific strata lot. The landlord must ensure that whatever parking rights it is to give to the tenant, it in fact controls such parking rights. A tenant should ensure that if it is leasing a strata lot, that the parking that goes with the strata lot goes to the tenant. Common property. In a commercial strata lot lease, the tenant has no greater rights to the use of common property than does the landlord. The tenant in a commercial strata lot lease situation should determine what common property is available for the use by the strata lot which it is leasing, or which is available to commercial strata lots generally. J. Limited common property. In a commercial strata lot situation, the tenant should ensure that there is allocated to it whatever limited common property is specified for the strata lot it is leasing. K. Insurance. Under the Strata Property Act, Section 49, it is the strata corporation which must insure the building, and it is the strata corporation which is responsible for rebuilding in the event of destruction. The landlord has no such control. At best, the landlord can only use commercially reasonable efforts to cause the strata corporation to rebuild. Therefore, there must be no obligation in a commercial strata lot lease obligating the landlord to rebuild. There should also be a right to terminate in the event the strata corporation elects not to rebuild. The landlord should get insurance for the improvements in the specific strata lot it owns. L. Hours of operation. The landlord will not, unless it controls the strata corporation, be able to control the hours of operation in a strata development. It will be under the control of the strata corporation. The strata corporation can restrict access to common areas of a building which may impact on access to the tenant's premises. This may be a breach of the covenant of quiet enjoyment. The landlord should be cautious when agreeing to the tenant's hours of operation. M. Signage. The landlord in a strata development may not have any control over signage. All common areas will be under the control of a strata corporation, and this will include pylon signage and signage on the exterior of the building, or the building. So on the exterior or the building. Okay. This can be a significant issue in a mixed-use development. The tenant will also have to consider if there are any strata bylaws limiting or restricting signage. All right. And that's the end of section 8 there. Stay